Hello, my lovely people. Once again, you are welcome to our channel. As always, this is Francis. I'll be your tutorial for today. We are discussing the concept of separation of powers. A very interesting topic. So, if today happens to be your very first time joining us on this channel, just feel free subscribe, like, share, comment, as always. And if you have any questions after this session, just drop it for us and we will respond to it appropriately. So then again, we'll try to make this video very short and straight to the point so that it doesn't become too lengthy for you and hopefully you would enjoy it. So let's get into business straight away. So in this tutorial, we'll be talking about separation of powers, some of the theories on separation of powers, and then separation of powers under the 1992 Constitution. So someone will ask, what is separation of powers? So the whole idea of separation of powers is really simple. All that we are trying to say is that powers within the various arms of government must be different and must be separate, if I'm allowed to use the word. So essentially what we are trying to say is that the different arms of government must be independent in what they are doing, and the powers and functions that they play must also be very different. Now, when I say the various arms of government, I'm talking about the three main arms of government, which is the legislature, and the business of the legislature is to make laws for Ghana. The second, which appears to be the most prominent, even though all the arms are equal, is the executive. And the executive is to ensure the day-to-day running of the business and also to ensure that the laws passed by parliament or the legislature are enforced by them. So in the legislature, we are talking about parliament. In the executive, we are talking about the president, we are talking about the ministers, we are talking about the DCs, the MCs, the municipals, all those guys, they come under the executive. We have been talking about the police, the army, the service, they all help in implementing the laws and ensure the day-to-day running of the state. Then finally, we talk about the judiciary, where I find myself, which is that the judiciary is supposed to interpret and apply the laws passed by parliament. Now, from the onset, you would know that all these arms of government need the other. However, we are saying that the basics of this concept is that these arms of government must be different, they must be separate. The function that they perform must not be the same. They must be, different, because if care is not taken, it could give room for abuse of power. So we are just saying, in order to avoid abuse of power by any arm of government, these arms of government must have separate powers and then must have separate functions. So essentially that is what separation of powers tries to do. Good. Now, in the very popular case of Youngstown Sheet and Tubeco versus Sawyer, it's now you would notice that in this tutorial we try not to bore you with too many cases, but please, for the very few cases that we try to mention, it would be in your interest to at least keep them in mind or possibly read about them, because most of these cases are very popular. So in that case, the US Supreme Court held that the president, I think at that time was Nixon, if I'm not wrong, had no power to undertake the functions that were preserved by parliament. So I think in that case, the owners of the steel business were negotiating with the government, and then I think the government needed the steel industries to continue, providing steel so that weapons could be manufactured out of them for war. And the government of the day thought that it could not, wait and allow these workers or steel industry players to do what they were doing. So, it passed the law saying that they cannot go on strike. And the Supreme Court had to come in to say that the president didn't have the power, to make those declarations. Good. So essentially, what it was saying was that, I mean, it's here. I don't want to bore you so much. So, just so for the purposes of what I'm saying, and to also put it in context, what the court was saying was that the president could not prevent, owners of private properties from going on strike, because essentially what the government was saying was that they could not stop the production of the steel for the manufacture of the arms. So it was the duty of the lawmakers to do that, and not for the president to force them not to go on strike, to ensure that their fundamental rights to work and to be, paid for fairly were ensured. So essentially that was the case in Youngstown Sheet and Tube and Co versus Sawyer. So certain concepts have underpinned this idea of separation of power. You should understand that separation of powers has been around for a very long time. It's not a very new concept. So you have the likes of John Locke and Montesquieu, all postulating about what the idea of separation of powers is. Now, according to John Locke, he was saying that it was very dangerous for those who have power to make laws to also have power to execute them, meaning that it will be very dangerous for those who have the power to make laws also be the same person to execute them, because then they would only make bad laws and then they would just go ahead and then execute them. So according to John Locke, there must be some differentiation between who makes the laws and those who execute them. You would understand that, and if you have been following the tutorials, you understand that there was a point in time in Ghana where Kwame Nkrumah was the head of the executive and also a member of the legislature. So you can just imagine a president being part of parliament. Almost every law that are made in parliament must definitely be in the favor of the executive. So definitely there will be no independence in such a legislature, because the president is also a member of that. So that is why John Locke was saying that it is very, very, very dangerous if the same persons running the executive are the same persons running the legislature, then that will be scary. But I'm sure by now you are thinking that what happens to Ghana? Because in Ghana, we seem to have some ministers who are also members of parliament. And the idea even seemed to be, for most political parties, is that for you to be a minister, at least you should have won the seat in your parliamentary area, so that you become a member of parliament. So mostly those who don't win in their parliamentary constituencies, don't most of them are not appointed as minister. But here John Locke was saying that it's a very, very dangerous phenomenon which we should be very careful to avoid. Then again, let's also look at okay, so more on wanted to look at Montesquieu, but I think there's more on John Locke. So John Locke essentially was saying that in separation of powers, we have to differentiate between the various bodies and assign different functions. So different bodies must constitute the executive, the legislature, and the judiciary, and their functions must also be different. And this must be recognized in the Constitution. So you would notice that in our Constitution, different article deals with powers of the legislature, powers of the executive, and powers of the judiciary. Now, again, John Locke was also saying that there must be a separation between the office and the office holders. So meaning that different people should be manning the different arms of government, which I have already mentioned. So if one person holds an office in the executive, in the legislature, and in the judiciary, that is very, very, very different. Good. So we can also talk about Montesquieu. So for Montesquieu, in his book, The Spirit of Laws. So he was then again, what I mean, Montesquieu was essentially saying the same thing. He was saying that the powers of the legislature and the executive should not be placed in the hands of the same persons. So really the point, which is that you should not allow the same persons to be managing the executive and the same persons to be managing the legislature. So as I keep on repeating this, you can take a glance of the Ghanaian system now, where a majority of members of parliament may also be, ministers of state, other regional ministers, or ministers of the various agencies of government. But according to Montesquieu, according to John Locke, he was saying that we should separate the office and the office holders, in the various arms of government. So one person should not be manning these two major functions. But the principle is not just for the executive and the legislature, it applies to all three, which is legislature, judiciary, and executive. But most of it, and the clash seems to be with the legislature and the executive, where you seem to have certain persons playing very key roles in these areas. According to John Locke and then Montesquieu, this shouldn't happen. So essentially, that is the whole idea of separation of powers, meaning that the member of parliament should not be a minister, and meaning that the Speaker of Parliament should not be a cabinet member of the executive. I'm not saying that happens, but essentially that's what separation of powers says. So in Amega Chair versus Attorney General, like a recent Ghanaian case, where the court was of the view that one of the fundamental principles of the 1992 Constitution is the separation of power between the executive. There is separation of powers between the executive, legislature, and judiciary. Although the separation of powers is not absolute, it is the cornerstone of our constitution. So in Ghana, we don't have absolute separation of powers, and I'm sure you would agree, which is that that interdependency and the overlap, and then relying on other arms of government for work to be done. So you wouldn't and sometimes this is necessary, and the whole idea of separation of power is necessary for the purposes of checks and balances, to ensure that all the various arms of government are doing what is expected of them. So under our constitution, you would see that separation of powers really is the ending. The Amegacha versus Attorney General case, they cited Article 88 of the 1992 Constitution, which says that all actions against the state shall be brought against the Attorney General. So meaning that if there's any matter against the executive, any matter against the president, it must come to the Attorney General. So all matters against the state goes to the Attorney General. So yes, separation of powers in Ghana is not absolute. I mean, that is, it's how do I put it? It's so there's really the interdependency among the various agencies of government. I'm not sure how best to put it, but you would note that these arms of government depend on each other for work to be done. And even before we go forward, you would understand that it is the business of the executive to provide budget for all the other arms of government, and these budgets must be approved by parliament, even the budget for the judiciary. And you see, and if these budgets and laws from the executive goes to the legislature, the bills, I should say, these bills must be passed for the purpose of what the executive wants to do. Now, if the judiciary also do make interpretation and enforcement, it would be the duty of the executive to enforce them. And based on judgments of the court, the legislature can decide to pass certain law. So they seem to work hand in hand. There's always the checks and balances, because if the legislature, passes a law that is null and void because it conflicts the constitution, the Supreme Court has the authority, which is a member of the judiciary, to strike this law down. So there's always the checks, and balances between these arms of government. But the basics which we want you all to understand is that we are saying that the functions played by these agencies or arms of government must be different. The persons, holding the roles in the various offices and the various arms of government must be different. That is the fundamental principle. But on it, there's always that, flexibility between them. So separation of powers under the 1992 Constitution. So you can see that Chapter 8 of the 1992 Constitution deals with the executive arm of government. Chapter 10 and 11 deals with legislature and judiciary. So from the onset, you will notice that there are different arms of government, that the arms of government are separate as captured under the 1992 Constitution. You would also see under Article 58 that all powers of the executive falls under the president. So all the powers of the executive is with the president, and they are exercised on his behalf by the subordinates. So here subordinates, I mean, by the ministers and all the parties that fall under the executive. You would also see that the legislative power, is vested in parliament, and final judicial power is vested in the judiciary. So here, just from the onset, you can see that the functions of the various arms of government are different. You can see that the chapters dealing with the various arms of government are different. So if you get a question on separation of powers and you are supposed to discuss this, the first point you are talking about is that there is separation of powers under the 1992 Constitution. And the first point is that the various arms of government are captured under very different articles. And then again, the functions of the various arms of government are captured under very different provisions under the 1992 Constitution. This is something that you cannot miss when you are discussing the concept of separation of powers. So in the case of Center for Public Interest Law and Attorney General, it was held that within the executive power, so it is within the executive power to enter into international agreements. And when this has readily been done in accordance with law, the courts have no role to play under these circumstances. So what this case was saying was that the executive, that is, the government, has the power to enter into international agreements on behalf of Ghana. But when this is done very right, Parliament has no hand in it. No, sorry, the courts have no hand in it. Or I mean, ordinarily, what must happen is that in some international agreements, it must be brought before Parliament for Parliament to ratify. So you see, even for international agreements, Parliament must ratify. But here, the point in this case was that once they were done right, once they had been, Parliament had been informed and then Parliament were okay with it, the court had no role to play in it. So the court could not come and then set it aside because it was an international agreement. No, the court did not have any hand in it. Same in John Ephraim Baden. Here, it was also held that the court had no jurisdiction to issue policy directives. No, it is not the business of the court, to do that. It is the business of the executive, to do this. So these arms of governments have the various roles and the function that they play, and consistently the law has ensured that they are not interfered or meddled into by other arms of government. So whatever Parliament does is closed book. So the court cannot stretch its long arms to determine for Parliament what Parliament does. However, when Parliament issues an act which it contradicts or contravenes the provisions of the Constitution, yes, the court would have the right to come in. So here we are saying that separation of powers under our Constitution really borders on checks and balances. So there are various provisions in the Constitution where one arm of government, seem to be checking the other. So, under our Constitution, the president cannot travel outside of government without notifying. Sorry, without notifying Parliament, not the president. Sorry, without notifying Parliament. Again, it is the duty of the president, to always be presenting presidential messages, to us, to Parliament every year, the State of Nation address. So, just to check on the government to ensure that what they are doing is right. So on international agreements, I've already talked about it, which is that they must be ratified by Parliament before they become valid. So the government cannot just enter into international agreement just because we are in a crisis and we need help. They just enter into just any contracts. And over the years, we've had issues on this area where government, because of a particular crisis, will enter into very, very, very bad international contracts, and then these guys come back to enforce them, and we're always talking about hundreds of dollars, if not millions. So the idea has always been that was it ratified by Parliament or not? But sometimes the problem is that our parliamentarians even diligent enough to be checking whether these things are in our favor. Sometimes some of these things are a bit questionable, even though I know our parliamentarians are trying their very best. So I would not want to say more. So so then again, on the appointments of the executive, I'm sure you will notice that most of these ministers must go to Parliament for them to be vetted and then approved by Parliament. And even for the judges, going to the Supreme Court, yes, they must be vetted and approved by Parliament. So then again, the legislature is also checked because the courts have the power through what we call judicial review to strike down legislation that are not in conformity with the Constitution. So you see, there are a host of others. When you look at our Constitution, there are a host of others where arms of government are checking the other, making sure that they are doing, what is right. Same when it comes to, budgets and all that, judiciary, yes, they make the budget, but it must still go through the executive to be placed before Parliament to ensure that the budgets are approved. So they just cannot go ahead and be paying themselves. It must definitely go through the executive to Parliament. So there's always the checks and balances in there. So I've already mentioned this. So the executive has the power to determine the emolument of the members of Parliament. So it is the executive that determines, the payment and ex gratia and whatnot of parliamentarians. Then again, it is the duty of parliamentarians to pass bills from the executive. Then I've also mentioned that even for the judiciary, some of the appointments, are done with the president and sometimes with the approval of Parliament. So that is how it is. There's always that checks and balances on the various arms of government. I think that point has been made abundantly clear. So under our Constitution, there's also the overlap of persons. In other words, persons holding offices in one arm of government are not prevented from performing functions in other arms of government. And this I have already mentioned it, which is under Article 78, majority of ministers who are members of the executive are to be appointed from among members of Parliament. So that is actually part of our Constitution, which is that the president must ensure that the members the ministers being appointed are members of Parliament. And under Article 68, where the Speaker of Parliament, who is the head of legislation, also assumes the head of the executive. So in cases where the president, or the vice president are not in the position to, perform their roles, you have the Speaker of Parliament assuming the executive, role there. So there's always the overlap. There's always, one person performing two roles, in the that is our, constitution, and our constitution seem to have agreed and allowed that. And there are times where the vice president and any minister, can also participate in the proceedings of parliament, although they do not have a bill. So the vice president or, other minister can just go to parliament, be involved in the, the proceedings, but just that, that person cannot vote. Thank you. So essentially, that is separation of powers. Pretty very simple, pretty very interesting. The concepts are straightforward. There's really nothing ambiguous about it. All that we are saying is that the basic principle on separation of powers are that different persons must hold different offices within the various arms of government. But when it comes to the 1992 Constitution, we seem to see two phases. The first phase meaning that there's the checks and balances on the various arms of government, and then the other phase which is the overlapping, where you have one person performing double roles, either in the executive and then the legislature. Mostly, you hardly have executive judiciary. I'm not saying it doesn't happen, but mostly is the executive and then legislature where there is that overlap. So once again, thank you for making it to the end of this session. I appreciate your time. I hope it has been very beneficial to you and you have learned something. Again, if something is not very clear, you can just send us a message. We'll do very well to respond. Again, kindly subscribe, like, share, and have a blessed day. Thank you. Bye-bye.